Good afternoon. Thank you for joining me today for common missteps construction contractors make when suing the state of New Jersey and how to avoid them. My name is Jennifer Budd, and I'm an associate at Cohen Seglias in the construction group and the green building sub-practice group. Prior to joining the firm, I was with the New Jersey Attorney General's office, and I represented the Department of Transportation and the Department of Property Management and Construction. In this role, I reviewed bids for the Department of Transportation, I participated in bid protests, and I litigated construction disputes. In 2012, I decided to switch to private practice, and I joined the firm, and I've been doing similar type of construction disputes ever since, but now this time normally for private owners, some public owners, and then contractors and subcontractors. Should you have any questions during the program, you can ask them in the questions section of the GoToWebinar panel, and I'll address the questions as they come in and as time allows. So I will get started. Okay, so this presentation today, this is what we're going to cover. First we're going to define the state of New Jersey, because that is actually a term of art, and it's probably a little bit different than what you'd think. We'll talk about the New Jersey Contractual Liability Act. We'll talk about what is not the state of New Jersey, and then three specific state agencies: the New Jersey Department of Transportation, the DPMC, or the Department of Property Management and Construction, and then the New Jersey Schools Development Authority. And then at the final, we'll talk about statutes of limitation. So, state or not the state? Why does it even matter? So this goes back to sovereign immunity. This is a doctrine that has been around for hundreds of years. It essentially means the government cannot be sued unless it says that it can be sued. And it comes from British common law, when the idea was that the king could do no wrong. So how that applies here in the United States, since we don't have a king, what it means is that federal government and state government, they cannot be sued unless they waive sovereign immunity. So because it requires a waiver of sovereign immunity, that means that there must be, the states and the federal government have allowed suits, but only under certain conditions. So in New Jersey, in 1972, the legislature passed the New Jersey Contractual Liability Act, and this is how the legislature waived sovereign immunity, or partially waived sovereign immunity, for breach of contract actions. So this is the act, and it states, the state of New Jersey hereby waives its sovereign immunity from liability arising out of an express contract or a contract implied in fact, and consents to have the same determined in accordance with the rules of law applicable to individuals and corporations. So stop there, I'll break this down. So if there's an express contract or a contract implied in fact, that essentially just means that as long as there's some sort of written agreement with the state, or there's conduct or actions that show assent by both parties, the state and another entity, if there's some sort of contract, it could be oral, but some sort of contract, then the courts should apply the same rules that they do to corporations and partnerships and persons to the state. Now, here's where they add some conditions. They say, provided, however, that there shall be no recovery against the state for punitive or consequential damages arising out of a contract, nor shall there be any recovery against the state for claims based upon implied warranties or upon contracts implied in law. So, punitive damages, you hear about them all the time. You often hear about them in horrific accidents or catastrophic accidents. They rarely are actually granted in any sort of breach of contract matter, so that's not as big of a waiver. Consequential damages are a very big deal, and the fact that the state cannot be liable for them is something to really keep in mind. Consequential damages cover things like loss of profits or harm to reputation. These can be really big numbers, and they can be very significant. And in a normal contract, unless there was an express waiver, they're recoverable if you're dealing with a private party, but against the state, they're not going to be recoverable no matter what the state does. And that's, something to keep in mind. Okay, so we'll talk now about what is the state. So in the statute from 1972, they define the state, and it says state shall mean state in any office, department, division, bureau, board, commission, or agency of the state, but shall not include any entity which is statutorily authorized to sue and be sued. So what does this mean? Well, it means that is the Department of Environmental Protection, are they considered a department? They are. New Jersey Schools Development Authority, that definition doesn't state authority. It ends up, they are considered a state for purposes of the New Jersey Contractual Liability Act. Casino Redevelopment Authority, Stockton University, yes. New Jersey Turnpike Authority, no, they are not. They are not part of the state for purposes of that waiver of sovereign immunity. So that seems weird. You're like, can we really not sue the Turnpike Authority? They can. It's just, again, there is in the Turnpike Authority's enabling statute, which is a statute that creates it and says this body is going to be responsible for the New Jersey Turnpike, that specifically says that they can sue and be sued in its own name. So that means that absolutely they can be sued, they can be party to a lawsuit, and in fact, almost in broader circumstances, all of those waivers and that limited protection that the state put into their statute from 1972 doesn't apply to the Turnpike Authority. So the only thing that's actually going to limit any lawsuit against the Turnpike Authority is the contract. So that's what's going to govern, is the contract is what'll lay out the terms. You don't have to worry about any statutes or anything like that. Other entities, not the state under the CLA, which might be surprising. Rutgers University, so Stockton is part of that Contractual Liability Act. They're considered the state, and therefore there's limitations. Rutgers is not. Any local public entities, that we're not talking about them, we're really just talking about the state, but there's different statutes and there's different provisions and limitations that apply to counties and cities and school boards and things like that. And then port authorities. Most people think a port authority, that's such a big thing. They run these huge bridges and transportation systems, but a port authority is actually, it's considered a compact. It is what a compact is, for example, the Port Authority of New York, New Jersey, you have New York and New Jersey working together, and they have the same legislation, and it's considered a compact. So it's almost a different legal entity. But the Contractual Liability Act and that waiver of sovereign immunity doesn't automatically apply to the Port Authority. There has to be separate legislation enacted that would apply to the Port Authority. So if you're dealing with Rutgers, what matters is the contract. Same thing with local public entities. And then, as I said, there are different statutes that apply to port authorities, even though it's made up of New Jersey when you're talking, and New York when you're talking about the Port Authority, New York, New Jersey, or New Jersey and Pennsylvania when you're talking about the Delaware River. So what does the Contractual Liability Act do? Like, what is its purpose? Two things. What we basically said, that it allows the state to be liable for contract, which it should be when it breaches a contract. But what it does is it also makes it more challenging to do that and to preserve your claims, your valid claims. And it kind of sets up a bunch of barriers and steps that can really trip people up if you don't know about them. So we're going to talk about what it requires from you and how it impacts your right to file a lawsuit. So the first thing you have to do is notice. And notice is the big thing. So what it says, the statute says, and I'm going to say the statute or the CLA, which is Contractual Liability Act. I'll use them interchangeably. But within 90 days of an event giving rise to a claim for breach of contract by the state, you must file a notice with the applicable state entity, and that notice of claim must include the name, the nature of the claim, your reasons, and if you know, the total dollar amount. So if you have a contract with the Department of Transportation and there's an event that you think is a breach of contract, within 90 days of that, you have to send this notice to the DOT. And we'll go into the specifics of that for the Department of Transportation, but generally, you're putting them on notice. So event is obviously a very important part of this. What is an event? So here's some examples of what an event is, and we call it accrual. So you would have to give notice from when the event occurs or when the claim accrues. So here are some examples. If you have a state agency wrongly denies you access to the job site on the day you're directed to proceed, you would have 90 days from there. If you show up and the property is locked, the fence is locked, or the building is locked, then and you're going to be delayed, you can't start your work, even if it might just be one day, if you're going to want to be able to preserve that claim for that one day, either because of a delay or because of monetary impact, you need to put in notice within 90 days of that event. If the state entity directs you to install extra work and you think this is outside of your contract, you have 90 days from that direction to file a notice of claim. And then if the state agency directs your forces to stop and start for any reason, here I have in the example to accommodate another contractor, if you want to be able to recover for that downtime and that starting and stopping, you have 90 days to file a notice of claim. Here's a hypo. You're replacing sewer lines per plans provided by the state entity. Half the times you dig into the ground, there's a conflict with another line or some other utility not shown on the plans. Each time this occurs, it takes half a day to 3 days to resolve the conflict. Maybe you need to get more direction from the designer. Either way, it ends up taking you 6 months longer to do the work because of these unknown conflicts and the starting and stopping. When should you send notice? Best case scenario. Each time you hit a conflict. First time you hit a conflict, you send a notice, you send a supplemental every single time. I get it. That sounds really frustrating and very impractical given the type of work that you're doing. But the government will have no argument that every single conflict and every single minute of downtime they were put on notice of. Good. Send a notice that you're discovering conflicts and that there may be more. And then once you actually have the full scope, supplement. This is probably a pretty good approach, but they're still going to have arguments that they were not put on notice of every single conflict. I would say that this is a very common situation for contractors because a lot of times in the field, you don't know how often you're going to be disrupted. So whether it be that there's downtime because of this sort of conflict situation or because another contractor's in the way and you can't get the work to proceed as efficiently as possible, it is imperative at the very least that you put notice that you're experiencing this problem and that you expect it to continue to occur. And then, if you keep supplementing, great, but at least make sure that initial notice is that they're on notice and that you think it's going to keep being a problem. And that'll take away any argument from the government that they didn't have an opportunity to intervene and correct the problem. Worst case scenario, send notice after the problem is resolved, after you've spent the 6 months doing the work and you say, oh my gosh, this took me so much longer, so many more man hours, I'm double the amount of time that I had in my bid. Let me send my notice to the state At that point, since it's 90 days that you have to give the notice and it took you 6 months to do the work, this government might be able to argue that that first 3 months is waived and that you can't recover any costs from that first 3 months. So as I kind of, this is kind of goes back, but the CLA and construction projects, they just don't mix. And I don't think that, certainly in 1972 when the statute was enacted, I don't think that they really had an understanding of modern construction and exactly what can occur. And the CLA applies to all contracts with the state, whether it be a lease or a contract to provide paper or to print. So it's this statute is having to fit a lot of different scenarios, and it's particularly challenging for contractors and construction contracts. As that is because an event, can occur every hour. It can be an event that goes on and off, starts and stops, and all of these things have a cost and a time impact, but making sure that you preserve your claims are particularly challenging for contractors. It is not the case that you just have an unpaid invoice, and so 30 days after the invoice isn't paid, you can send your notice to preserve the claim for the unpaid invoice. If that was it, it'd be easy. But for contractors, it is much more challenging. The other thing that makes it challenging is there's just a lot of different people that have responsibility. You could have a supervisor, a project manager, multiple supervisors, and that just can make it challenging to make sure that the notices are being done. What I think successful contractors who have a procedure to deal with the CLA, what they do is they identified somebody who's responsible for actually sending the CLA, and they make sure that everybody knows to send their issues to that person, whether it be project manager or a great field supervisor, and make sure that they are alerted to every single issue, and then they have to be the one to actually make sure that the state is put on written notice. So you can bring a late claim. However, to do so, you're going to have to incur some costs. So there is a procedure in the CLA that says if you fail to bring your notice of claim within 90 days for up to 1 year after the occurrence, so essentially you're getting another 9 months, you're going to be allowed to file a notice of claim, but you have to petition a court. So that means you either have to petition the court yourself, probably involve an attorney. You're going to incur costs on something that's fairly easy to do if you know about it. So it's a good thing to have in your back pocket if you ever have to, you realize that you have this big claim and it slipped through the cracks. As long as it's within that 1 year from when it occurred, you can petition the court to allow the late claim. And courts are pretty liberal with allowing that, but you're going to incur more costs to do that. The state, to avoid having the court grant that extension, that 9-month extension, essentially, the state has to show that they were substantially prejudiced. So that is a pretty high standard, substantially prejudiced. How the state would probably do this is that they would say, had I known that you were having this problem, contractor, I would have done X, Y, Z. So in my example of these unknown utilities that are buried when you're trying to replace sewer lines, they might say, contractor, had I known that you were starting and stopping so much and you were having so much problems, had you told me, I just would have done more test pits. I would have just done more subsurface investigation. And that would have been cheaper than having to pay you for, 3 months extra labor. And in that case, I'm not exactly sure how a court could roll on that, but I do think that there's a decent chance that's a good argument from the state. So if it's something that they could have done differently had they known, then that might be the reason why you are not given that 9-month extension. So you file your notice. Let's just say you file your notice and you have this claim, and the state isn't paying it. They're saying, go pound sand. We don't think that you're owed any extra money, and you say, I have a breach of contract action here. What do I do? Well, you have to wait 90 days after you brought your claim. That is so that the state has time to investigate it, talk to the right people, ensure that they have all the facts, they've preserved the documents, they've interviewed the project manager, the RE, whoever it is, they know everything. It gives them a chance to kind of get their house in order. If you still have the dispute after 90 days, you absolutely can sue. So you can sue after the 90 days. It'll be a bench trial or a trial by a judge, no jury. You, by entering into a contract with the state of New Jersey, you're automatically waiving your right to a jury trial. In some respects, that's good, but it is a unique feature of contracting with the state. You also have a smaller window to sue. So even though you have to wait the 90 days, you can only actually sue up until 2 years after the event occurred, or 1 year after completion of the contract, the complete contract, whichever is later. So it normally ends up being the 1 year after completion of the contract is later. That tends to be the case, but either way, it's a smaller, essentially, statute of limitations, which means you have to get your lawsuit filed. You can't wait as long as you could if you're contracting with a private entity. So what are the downsides to failing to follow the CLA? You might completely lose your right to sue because if you don't file your notice, you can't sue at all. And if you don't file your timely notice or get the extension, then you can't sue. Even if you are able to get that extension, or you're on the border with your notice, or something's flawed with your notice, there might be motion practice, which is what we call when we have a lawsuit and there's just motions that are filed. It just gets more expensive. It makes the litigation more expensive. So if you have clean notices, that'll likely keep the litigation a little less costly. It's harder to settle, honestly, because states spend taxpayer money, they have to do their due diligence, and they can't just they don't make the same business decision that you do. And I saw this when I represented the DOT. There is really, truly a fairly deliberative process, and it can take a long time, maybe too long, but either way, there is some sort of deliberation that has to occur because they're spending taxpayer money. So that means that if they're not put on notice, they might not have the witnesses or the documents and be able to feel like they've done that deliberation in a knowledgeable way. So then they're just not going to settle it. They're just going to kind of wait and buy their time until they're forced to make a decision through litigation. And that's frustrating when there's a valid claim and you just, the state's not making that informed decision that it should make. It's just in your best interest if you there's nothing to be gained by not giving them notice. So as a review, the Contractual Liability Act applies to many more state agencies than listed here, but for construction, particularly relevant, DOT, New Jersey Schools Development Authority, DPMC, Casino Reinvestment Development Authority, basically the Department of Treasury, any of their sub-agencies, the CLA applies to. New Jersey Turnpike Authority, Rutgers, they are not CLA entities, and so the contract is what you have to worry about there. So, and then you also have 90 days to get in your notice of claim. You have to wait another 90 days before you can sue, and then you have that shorter time period to actually file a lawsuit. So now we're going to talk about some specific public agencies. The contractual claims requirements in the contract that each state entity has, they can actually make stricter requirements than the CLA. That might seem counterintuitive, but essentially, if you consider the CLA kind of like a floor on the minimum that you must meet to be able to sue the state, by contract, the state entities can make it even harder. And some entities certainly have done that. For example, the DOT. So New Jersey Department of Transportation, they say that in section 107.04 that there are notice provisions that must be met, and section 104.03.04 and this 107.12.01, they lay out those notice requirements. So this is the first notice provision, and it's quite different than the CLA in that it requires a contractor to immediately provide written notice to the resident engineer of any circumstance that are considered a change to the contract. So immediately. And what that notice must include, it's pretty cursory, but it has to be in writing, and you're going to have to say what the change is, when you discovered it, descriptions about it, whether you think it'll affect the costs, and whether you think it'll impact the date of completion of the contract. You don't have to have that quantified. You just have to say, yes, this has a cost impact, and yes, this has a schedule impact. So what is a change? Well, it's pretty broad. An increase or decrease in a quantity by 25% or more, any delay, any differing site condition, any extra work item, constructive acceleration, and inefficiencies. Basically, any impact that you can have on a construction project, that's considered a change that you have to give immediate notice of to the RE. Otherwise, you risk losing your right to recover that claim later. The reason this is a problem is that if you read further in that section, the second bullet here, it says, quote, the contractor waives its right to file a claim for costs incurred before providing notice to the RE. So if on Monday you're directed to do extra work that you think is outside the scope of your contract, you do it, and on Wednesday you send the notice saying, we think this is extra work, we're going to recover a claim, you've already waived that claim under the contract. You have to give the notice before you do any work. You don't have to wait for their response, but you have to say, we think this is a claim, we think this is a breach of contract. And that again applies to delay, any differing site condition. With a differing site condition, if you show up to the job and you start digging and you find a World War II era ship that you didn't know was going to be there, that's clearly a differing site condition. You have to actually alert the RE immediately, do your notice, but then you do actually have to, you can't disturb it. You have to let the DOT have a chance to inspect the condition, and that's any differing site condition. For the notice, the RE is supposed to respond in 5 days. So to do this notice, I highly recommend, you don't have to use this form, but I highly recommend it because it kind of walks you through everything. It's called the DC-161. It's the easiest way to make sure that you're covered under the contract and the CLA. It is dual purpose. So the form lays out everything. It has questions that it prompts you with, and it kind of walks you through all the steps. And you fill in some details. Then eventually you're going to get to question number 9, and it's going to ask you this, and this can be a little confusing. It says, why are you giving me this? Are you giving me this for notice, or are you giving me this to start the claims process? At this stage, as soon as you have the problem, you're directed to give the extra work, you're just submitting this to give notice. So you're going to check the first box. And that means that you're just giving cursory information. You might not know all the facts. You might have to supplement it, and you absolutely do not know the amount of time or the costs that are actually going to be incurred because of this change or this condition. And that's fine. So you check that first box. The DOT can now say that they can no longer say that you didn't give notice under the contract or under the CLA. Everything's preserved. You're in good shape. So you should provide this immediately. Give these, you can give in, there's electronic copies, even a paper copy would be fine. Give them to your field supervisors, give them to your project managers. They're very easy. It's a 2-page form, a lot of boxes to check, yes and no. Some writing, but it's a very simple form, and it's the best way to make sure that you're covered. The one thing that you do want to tell your employees who are signing these is that you are certifying that the foregoing statements by me are true, and that I'm aware that if any of the foregoing statements by me are willfully false, I'm subject to punishment as may be provided by law. This is essentially a certification under oath. You want to make sure that you're as accurate as possible. That means the key word here is willfully false. So as long as you're not submitting a claim that could be considered an intentional false claim, you should be fine. But you do just want to make sure that, whoever is signing this is as accurate as they know. They have all the information that they know, and that is accurate, just because of this certification. So the next provision that the DOT says is important for notice is if you actually want to elevate your claim. So you've submitted your notice. In the extra work example, say the RE says, you know what, no, you also have to go pave over here. And you say, no, that's not in my contract. Look, here are my paving limits. And he says, no, I think you do. And so you put them on notice immediately, you do the work, and now you know that work took you an extra week, and it has a $75,000 cost impact. So you say, okay, I have a claim. So at this point, you can go through the New Jersey DOT claims process. There's 4 levels. It is pretty time consuming, but for smaller claims, it's a fairly good way to resolve them. So the first level is the RE. The second level is called the Dispute Review Board, which is just a smaller group of persons, tends to be more regional. So if you're working in DOT Central, which is a part of a region of the state, then it's going to be kind of more of those people. They're South, Central, and North, so it's going to be a little more regional. And then the Claims Committee, which is actually a very big group. It involves attorneys. You can, as the contractor, can bring an attorney to the Claims Committee, but you cannot to the other ones. You can put on a presentation. It has DOT executives on the Claims Committee, and they hear claims from all different types and all different issues. And then non-binding mediation is the last step. So to even start the process, though, you have to have a full and complete DC 161, that same form we talked about, plus these 12 additional items that we'll go over. And the DOT will not even start the process. The RE will not look at it until it's complete, until they deem it complete. If you submit it and it's not complete, they'll tell you what you're missing, and you have to submit it again. So if you're going to do the claims, this is where you're going to check that second box. So you'll fill out the form, and you are basically in this going to certify that you have attached all the documentation that's requested, everything to support it. You've quantified the cost. You've quantified the time extension. You have a CPM fragment diagram with any request for a time extension, and everything's ready to go. You are fully able to make your claim with the documentation that's submitted. And so when you check this box and you send it to them, you're saying, I'm ready to go. This is everything I have that supports my extension of time and or my additional costs. So with your DC 161, these are the things you want to submit. Detailed statement providing dates, location, items of contract affected by the claim, dates, your original notice. You want to have essentially all the key people that are involved. And this is because if they want to talk to anybody or ask that they attend, you want to have your key people that know from your organization or from the DOT. The specific provisions that you think matter to your claim. Mitigation. So mitigation is a duty that's imposed on everybody in a contract. And what it means is that if you're saying the DOT breached the contract, and they did, you as the other party to that contract can't sit there and just wait until the damages accrue. You have to try to, what they say, mitigate your damage or lessen your damages. You have to take reasonable steps to decrease the liability of the DOT. So in a very common circumstance, if there's an interference and you're not going to be able to work for most of the day, most of the time, if you can, if they're, it kind of depends on collective bargaining agreements and things like that. But if you could send some people home or, decrease the equipment load on a project, if you can decrease the costs that are incurred from that downtime in some manner, you got to do that. You just can't sit there and let everybody keep racking up the cost for this downtime that the DOT caused. So you're going to want to lay out exactly what you did to decrease the costs that are caused by the DOT's wrongful act. So if the claim related to a matter the contract puts in the DOT's discretion, you must lay out why that decision by the DOT was wrong. You're basically just going to say, you know what, I understand this was something that you had the discretion to do, but it was really just completely off base, and it was really harmful. So that's a little bit harder to describe, but really you're just laying out again why the DOT, what they did was just completely off base. You want to attach any emails, any letters, anything that discuss this issue and support it. If you're seeking an extension of time, you need to quantify the days. You're going to want to give your time impact analysis and all information to support that time. And really on the cost, this is where you're going to give all of your information. You should not hold it back. Give your daily tickets, your daily reports, certified payrolls to show costs, pictures of the event. If you're trying to claim equipment, you want to do your Blue Book equipment watch sheets that show the rates. You're going to just essentially everything you need to prove every single dollar you want to include. And then you have to state that this is all the documentation I'm giving you, and you're requesting the review process to begin. So the reason why you want to make sure you don't hold anything back and you're thorough and you give everything is that you as the contractor are limited for the entire claims process to what you submit at the first stage. If at the first stage they say, you know what, yeah, we think this is a problem, but we think it's only worth $25,000. Your cost documentation doesn't support the $75,000 that you're seeking. Unfortunately, you're not going to be able to supplement and show why you actually do have another $50,000 in damages at level 2. You're not going to be permitted to supplement the record, as we say. So you want to make sure you're very thorough in the beginning. And then luckily the contract does say that the DOT has a certain amount of time to respond. It varies by level, but either way, it's not an unlimited amount of time. They have a certain amount of days, 30, 45, something like that, to respond. And then if you're dissatisfied and you want to elevate the claim to the next level, you have to make sure you act within certain time periods. They're generally between 10 and 20 days, and it varies on the review, on the level that you're at. The one thing also to know about the DOT claims process is it's actually not required. So you can actually just, after you've given your notice, if it's the end of the project, and as long as you're within that statute of limitations, you can just sue. You do not have to go through the claims process. And many times we advise clients to skirt that claims process, especially on a big claim. If it's probably over half $500,000, we often would just say, just file your lawsuit, because the claims process can be very onerous and very time consuming. But on smaller claims, I think it's actually very useful, and it should be done, because you can, without actually having to use an attorney or incur those costs, you can potentially get to a point where you're trying to strike a deal with the DOT. And it's pretty straightforward what you need to do if you read the sections on claims, which is section 107. But on bigger ones, that's when you have the conversation whether you think it's worth it or not. So for the DPMC, this is the Department of Property Management and Construction. So they are the agency that are charged with basically building buildings for the state of New Jersey that are not schools. So when I represented the DPMC, we had a bid protest on building a new licensing center for the Motor Vehicle Commission. We had litigation over a building that was at a wildlife refuge that was the siding was falling off. So they build all types of buildings for across the state, as I said, Motor Vehicle Commission, state park, any sort of construction that's not schools, they're probably going to be the agency that's responsible for it. So for being such an agency that has such broad responsibility, they remarkably don't have nearly as sophisticated as specifications as the DOT does. Their specifications are only about 15, 20 pages. They were updated in December 2015 for the first time in 10 years, and that's where they actually put in for the first time a type of claims procedure. So it basically says if the state employee or the architect engineer denies a change order request or an extension of time, you can go to some sort of claims process with the DPMC. So you present a claim, and then they're just going to schedule a conference. That's all it is. Very, very simple, not nearly as formal as what the DOT requires. But they did put this into the specs. They say that DPMC's participation in negotiation or settlement does not toll or extend the time limits. So, for example, say you submit a change order request to the DPMC. You say your architect told me to do this. I think it's outside the scope of my contract. I think it's extra work, and it's about, it cost me $20,000 to do it. And you submit a change order request for that. Comes back denied. So then you say, yeah, I want to be able to have this conference with the DPMC, and we're going to sit down and we're going to talk about it. And so you request that you have this conference scheduled, and they say, okay, we'll schedule it. You know what? It's the holidays coming up, and everybody's out of the office. So January 15th, and you say, okay, great. Well, the problem is that if on January 10th, the 90th day from when you were told to do the extra work occurred, your claim's gonna be denied. And the fact that they agreed to meet isn't gonna impact that at all. They are essentially saying that it does not matter if we agree to sit down with you. It does not matter if I'm even trying to negotiate the amount of the change order. Whether I say, yeah, I agree with you that it's extra work, but I only think it costs $10,000. That is not going to affect it. You still have to put in your notice within 90 days of the event under the CLA. So just as a matter of course, get that notice in, and then you can negotiate for as long as you want with the DPMC, as long as you still file your suit within 2 years of the event or a year of completing the contract. So if you get the notice in, you're good. So again, just don't wait until the claims process is over to put in your notice. Do it the other way around, put in your notice. So the New Jersey Schools Development Authority, they also have a claims process, and they have their own form. It's called the 505. So it does say that you should use the 505. That'll be noticed under the CLA as long as it's done within the statute of time. It also covers the notice that's under the contract. This is the form. It's pretty simple. This is not complicated, just some general information. Your contact information, you describe it, and then the dollar amount. Again, the dollar amount does not actually have to be quantified at the time of the notice. You can supplement that. The CLA does not require it. So if you don't know it, fine, supplement it after you know it. So there are it's a two-step claims process for the NJSDA. First, you're going to they review the SDA reviews it. So you submit your form. With your form, you're going to want to give all your documentation to support the cost and the time extension. It's very similar to the DOT in that respect, is that you want to get everything in so that to support the liability, meaning why they owe you any extra money or an extension of time, and then the amount, the cost and the amount of the extension. Like the DOT, the SDA will not review it until it's complete. They have 60 days to review the claim. And then once they send you a letter, and if they say, we're denying your claim in its entirety, or we think it's only, worth a third of what you request, if you're not happy with that, you have 15 days to then write back and say, I reject this decision and I want to go to the next level, which here would be non-binding mediation. So that 15 days is pretty tight. So you got to make sure that you're on it. you immediately reject it. The non-binding mediation is also at the SDA's discretion. They can waive it. If they waive it, then your next place is to file a lawsuit, essentially, and again, be a non-jury trial against the SDA. So to review, New Jersey DOT contracts have stricter notice requirements than the CLA. You must give notice immediately. The DPMC and the NJSDA do not shorten the notice requirements, but they do have other type of claims processes that you should know about. Similar to what I just said, at minimum, you have to comply with the CLA. There are basically zero exceptions to it. So if you don't do it, or if you don't acquire that extension, you're not going to be able to sue the state and recover those costs. Statutes of limitations / statutes of repose. So what is a statute of limitations? It is essentially a cap on when a lawsuit may be brought since the harm occurred, here a breach of contract. In normal circumstances between two private parties, corporations, partnerships, individuals in New Jersey, you can bring a breach of contract action for 6 years after that breach occurred. However, as we talked about, it's shorter for the state. What is a statute of repose? It is a limitation that caps when a lawsuit may be brought. It's based merely on the completion of an activity. So in the construction context, the statute of repose runs from when the completion of the work or the project. It's kind of project specific and work specific, but it's 10 years. So that essentially is like an end cap for when lawsuits can be brought from the work. And you have to meet both. You have to be within the statute of limitations and within the statute of repose. So as we talked about, the CLA shortens the statute of limitations from 6 to 2. So you only have a third of the time that you would when dealing with private entities. And then, as I said, so you only have a third of the time. It's the 2 years after the event or 1 year after the project ends. The interesting thing is that if you breach the contract, the New Jersey law allows the state to sue you and come after you for up to 10 years after the occurrence. So it's not reciprocal. Just because you have all these conditions before you can sue the state doesn't mean the state has the same conditions. They don't have to put you on notice. They don't have to do anything. They just have to make sure they file their lawsuit within 10 years. So it's pretty forgiving for the state. So lessons. Make sure you're familiar with the notice provisions in the CLA. Ensure that you've read your contracts, because as I said, the contracts can impose stricter requirements as the DOT does. You should, as a matter of practice, just put in written notices in every event. You can never give too much notice. You really can't. Be mindful of the amount of time you have to sue the state and how much time the state has to sue you from an event. It is important to realize that the state has such a long statute of limitations, because if you have an automatic deletion of documents after 6 years or 8 years, that could be a problem for you when you're trying to defend yourself. Obviously, employees move on, and you can't really necessarily prevent that. But because the state has 10 years, it does mean that, and we've had this with a client. The state brought a suit in year 9. And luckily, they still had the documents, but of course, they were in a very dusty storage unit, off-site. So that took a little while to locate all those documents and find it and be able to defend ourselves. And just generally plan on filing a lawsuit with 1 year of completing the project. So I don't see any questions. I'll stick on for another minute, but if you have any questions, please let me know. We will be emailing this webinar out, so you'll have it. You'll have the recording and the slides. My contact information will also be there, so please feel free to contact me afterwards with any questions. We'll be offering more webinars on additional topics in the coming months. Our next program is scheduled for September 12th. Partners Brian Lawton and Wayne Buckwalter will present business succession planning strategies for the transition. More information can be found on our website. And please feel free to contact with any questions. And thank you for attending, and enjoy the rest of your day.